Hello, and welcome to Thinking Boldly. This is the podcast series for the Concilium Institute. I am retired Judge Julie Field. I am a co-founder of the Concilium Institute, along with my colleague Heidi Webb. The Concilium Institute was started as the bold answer to what's next in family law, and we bring to you experts from around the world who really are focusing on those bold answers. We are very, very excited today to have Professor Lisa Fishbane-Joffe join us. And I'll turn to my colleague and partner, Heidi Webb, to do a more complete introduction. But Professor Joffe, thank you so much for joining us here today.
My pleasure. It's my great honor to introduce our audience today to Dr. Lisa Fishbane-Joffe, who is the Shalomit Reinhardt Director of the Hadassah Brandeis Institute and a faculty affiliate in Near Eastern and Judaic Studies at Brandeis. She is an expert on women's rights under Jewish family law and on the intersection between secular and religious family law. She's written numerous publications on gender, religion, and family, theorizing about conflicts between women's rights and cultural traditions. She is the editor of the Brandeis University Press series on gender, culture, religion, and the law, and of the HBI series on Jewish women. She is co-founder of the Boston Aguna Task Force, devoted to research, education, and advocacy for women under Jewish family law. She holds 3 degrees from Osgoode Hall Law School and Harvard Law School, served as law clerk to Justice Iacobucci of the Supreme Court of Canada, and was called to the bar of the Law Society of Upper Canada. Before coming to Brandeis, she taught English law and comparative law at the Faculty of Law's University College in London, England. It's with enormous pleasure and a great honor to welcome you to our podcast today, Lisa.
Thanks very much.
My question for you is, your amazing biography really focuses on Jewish family law. And as someone who was presided over a court as a judge in the secular side of the law, I will be honest with you, I don't really know much, if anything, about Jewish family law, just a little bit that I've learned through some reading and some conversations that I have had with folks like you and Heidi. But help me really understand and help our audience understand who may not be familiar with it. Kind of when you say Jewish family law, what is that?
So when a Jewish person gets married in the United States, the ceremony may be conducted by a rabbi who is also a licensed marriage officer of the state. So it may look like it's one single ceremony, but it's actually 2 legal marriages that are being created. One is the secular marriage that's honored and marked by the state in which they're residing. And another is the Jewish marriage, which is created under Jewish law. And should the marriage fail later, it has to be dissolved through 2 distinct processes. One is dissolution in the secular courts, and the other is dissolution under Jewish law in a rabbinical court.
Can I ask a question, Lisa? Why? Why would there be 2 marriages when, most Christian faiths say don't have a tradition like that?
Well, I think for many centuries there was not secular marriage. There was only religious marriage. So in Christendom, the marriage that was recognized by the state was Christian marriage. In Islamic countries, it was Islamic marriage. So Jews, in order to have marriages that were recognized under Jewish law and that were considered in compliance with biblical commands, had their own religious marriage processes. They didn't have access to other forms of marriage offered by the state. So a regime of Jewish marriage grew up alongside whatever secular things have developed over recent centuries.
And that was maintained when the diaspora of Jews across the world, I guess has always been this tension between state and religion. And so you're saying that this followed that history and was maintained.
At a certain point, Jews became able to take advantage of secular institutions where Jews became equal citizens in some European societies and in North American societies. But for many people, many elements of Judaism, it's important to also have a religious marriage. For some people, that's ceremonial in nature. So people who might marry in Reform or Reconstructionist um, elements of the community might not need to have a religious divorce. That might not be important to them. But those who marry in an Orthodox or conservative ceremony, those forms of marriage are not simply ceremonial. They have status import, and they need to be dissolved through appropriate Jewish law processes.
So does that mean that the rabbinical court also would have say in the relationship between married people and their children, what we would call custody sort of in the secular court? Or how does that play out? Or where's that tension between the religious sort of authority and the state authority when you have sort of like two different vantage points on the same marriage?
So for the most part, in the contemporary sort of American scene, rabbinical courts don't get involved in custody matters. They there is also a principle of Jewish law that that rabbinical courts should respect the law of the land, and the law of the land is that decisions about children should be made based on secular principles about the best interests of the children. So generally, when matters go to rabbinical courts, it's issues around the solemnization and dissolution of the marriage. That doesn't mean that custody might not come in as a bargaining tactic by one or the other side in order to try and achieve some kind of advantage in rabbinical court that's not available in secular court.
So is this something that has equal, that women and men sort of have equal ability to access? Or what is the power sort of dynamic of the rabbinical court? If it's not really effectuating something that the state really has the authority over, but it's more solemnic in nature, related to sort of the solemnization, how does that play out between a couple, hetero and a sort of straight couple, presuming that.
Yeah, we can talk about same-sex couples later, and that is a slightly different situation. So it does have significant uh, differential impacts on men and women. So basically, there's a fundamental inequality at the heart of Jewish marriage. So Jewish marriage is not a relationship of legal equals, and it is a relationship that is created through the acquisition of the wife by the husband. And it is a unilateral contract in which the husband agrees to take on obligations to the wife. She doesn't make any kind of similar statements. She simply, consents by her presence. And for the marriage to be dissolved, similarly, it is dissolved through the act of the husband, not through the act of the wife. So a marriage is dissolved through the delivery of a document called a get, which is a bill of divorcement, which is sort of based on a biblical model, and it's been developed in Talmudic sources. And the notion is that the husband has to deliver a bill of divorce to the wife and tell her, you are now free to marry other men, and she receives it from him. So there are important distinctions between the rights of men and the rights of women. So women do not have the right to initiate divorce or the capacity to initiate divorce, and husbands have the capacity to withhold a divorce if they don't wish to grant one. And that becomes a significant bargaining endowment when the couple is seeking either a religious divorce or also becomes a bargaining endowment in negotiations around a secular court.
So I don't want to. I want to continue that conversation, but I have a question, sort of going a little bit backwards into when you're talking about a contract that was initiated at the time of the marriage. If I'm not mistaken, there's a ketubah, marriage contract in Jewish marriage at the beginning. But if you're saying that this isn't a contract between, like, it's not offer and acceptance in the traditional sense of the law.
Yeah.
It's really laying out of a role in the marriage more, and that only the man in that dynamic would have the ability to grant sort of well, as you're saying, a bill of divorce. Is
That's
that
correct.
right?
That's right.
Hmm.
So
Okay.
the important distinctions between Jewish marriage and secular marriage is that only the husband can initiate the divorce, and it can't be delivered over and above his objections, and that the divorce is actually not something that's granted by the court. The court supervises the delivery of divorce, but the rabbinical court can't give a divorce over and above the objections of the husband. It has to be coming from the husband.
Okay, Lisa, I'd like to just go back to one thing that you mentioned, which is the initial ceremony, that there's really two ceremonies within one in a Jewish marriage. And I was just at a Jewish wedding this past weekend, and this is a young couple signed a ketubah, and then they read it out loud to the people who were gathered there to celebrate the marriage. So help me understand, kind of what the meaning of that is. I'm assuming that that's what created the Jewish marriage, right?
So it is created through a ketubah, and I want to make a point about the way people engage with Jewish law. So there may be people who are engaging with the marriage contract and who really understand that they're creating a legal relationship. But often people may engage with Jewish law because they value the ritual, that it's a meaningful thing to sign a document that has this centuries-old heritage that, as you say, is read out in this ritual fashion. There are other elements of the Jewish marriage ceremony that may be really evocative, and they want to engage in some practice that's meaningful to them and also is recognized by their community. They may have, there may be people who simply want the ritual elements and are not concerned with the legal element. There may be people who kind of do both. And I was mentioning earlier, when I got married 32 years ago, we had two contracts. We had a traditional Orthodox ketubah, which is written in Aramaic and which I have rolled up in my drawer. And then we had a marriage document that we created ourselves, which actually we wrote, and it described what we thought our marriage or our aspirations for what we wanted our marriage to be. And our friend did the calligraphy, and my sister-in-law did the art, and we have that up on the wall to remind us of what this enterprise we were engaging in was all about. And both of those are legitimate ways of approaching a marriage contract. The issue around Jewish divorce and get-based extortion and get refusal emerges for people for whom the legal element of Jewish marriage is important. So people who are part of the Orthodox movement or conservative movement, and people who are concerned about whether children from any new marriage would be recognized as legitimate in the community, and are worried also about the status of any children from a future marriage.
Yeah, that's fascinating because I think often people are surprised, even when I consult with them on a secular marriage, that the state has a say in as many ways as it does in their marriage. And, I've said so many times to people, when you stand at the altar and you think you're just making vows with one person, there's actually a third party involved in this, and that's the state. That's the person who, is representing the state, who's marrying you, and you are also becoming bound by those laws at that moment. And people are very unaware of that generally. And I think this is sort of adding another layer. It's almost like if we had, tracing paper, or like one of those games that has, three-dimensionality. It's sort of like there are these other elements to it. And it makes me recall back to my own marriage when I was very concerned about having an egalitarian ketubah, which probably has no significance in the religious world and wouldn't have complied with anything that would entitle somebody to a get, which is sort of fascinating because, you are engaging in everything you said in terms of the ritual components of a Jewish marriage, stepping on the glass and sharing the wine and all the things people might think of when they think of sort of the more traditional elements. And this is sort of another piece of that. but it may not have been in compliance with, or I'm sure it wasn't in compliance with the Orthodox Jewish law.
Yeah, and I think I did something similar, and I think at the time it wasn't a violation of Jewish law. It was just it was legally null.
Right.
It had no impact on the legal relationship.
Right.
Right. It was a pretty to put on your wall, as you said.
Yeah, and so it's like even in the ceremony, I wanted an egalitarian ceremony. So I wanted to be able to say things to my husband and give him a ring, and the rabbi structured the ceremony so that he gave me the ring, and that was legally effective. And then there was like a musical interlude, and then and then I gave him a ring. It's like here's a ring, but it doesn't have any legal effect. Um, so I just wanted to add one thing that was kind of available at the time that I don't know what year you got married, when we got married, but I didn't know about it yet, which was a, uh, a halachic or Jewish law prenuptial agreement. And those started to be created in the early 90s and have become much more popular and have become really part of the marriage ceremony in some Orthodox communities or modern Orthodox communities. And that's a document in which the husband sort of says, I acknowledge I have this power to withhold a divorce, but I promise you now, in this moment when I love you and I wanted to do this for you, that if anything ever happens to this marriage, if you ask me for a divorce, I will give it to you. And if I don't, I agree to be subject to sanctions in a rabbinical court that would compel me
Mhm.
to deliver the divorce.
That's fascinating. So that's sort of, I know there have been some, obviously we've talked a little bit about refusal when a husband refuses to give a get. And that sort of brings up, there are some cases, I think, in the United States in the relatively recent past where there has been refusal and objection. And can you talk a little bit about how that's played out in the courts?
Sure. I wanted to take a little step back so that, we talked about the structural inequality in Jewish divorce. And that has always been a problem. There's always been a problem of women being rendered an aguna, or agunot is the plural. An aguna is a chained woman, a woman tied to a dead marriage. And in the past, in centuries past, there have always been agunots, um, but often for reasons related to the husband's incapacity to deliver a religious divorce. So either the husband, went on a business trip as a peddler and never came back, and we don't know what happened to him. Or the husband's physically present, but he's not mentally competent to deliver the divorce, either because he's in a coma or he has a mental illness that prevents him from forming the intention. So rabbis through the centuries had tried to create kinds of solutions for those kinds of situations, identifying a moment of lucidity when the husband was competent enough to deliver the divorce, for example. What we see now is not simply a husband who has disappeared, leaving his wife chained, or a husband who's mentally incapable of delivering a divorce, but a husband who is willfully refusing to deliver divorce because either out of spite or a desire to exert control over his wife or wife. Um, or because he's seeking some kind of tactical advantage in the secular divorce. There's a sense that as secular family law has become more egalitarian and has recognized relatively equal rights in property and child custody and maintenance in men and women, that this capacity of men to withhold divorce becomes a bargaining endowment they can use in negotiations for the civil divorce to get a more advantageous property settlement, to have the wife withdraw claims for maintenance, to have the wife withdraw restraining orders related to domestic violence in order to achieve delivery of the get. So that's when I use the term get refusal, I'm talking about the broad category of refusal. But when I'm talking about extortion, I'm talking about using threats to withhold the religious divorce in order to get women to either make payments, cash payments, or to drop claims that they legitimately have under secular family law in order to achieve freedom from their
Right.
marriage.
And I've done a lot of work in my career with survivors of domestic violence and dealt with that coercive control and litigation abuse. Right? Really, this is on some level that's what you're talking about. So it seems to me that this creates just yet another tool in the toolbox for someone who uh, it misuses power and control in an intimate partner relationship. So that's what I'm hearing you say? Is
Yes.
that accurate?
Part of what I do in my scholarly work is study the ways in which advocates on behalf of women denied a religious divorce or agunot have done their work and articulated their claims over the last decades. And one of the most effective developments has been recharacterizing divorce refusal as a form of domestic violence and
Hmm.
specifically coming to encourage the community to recognize it as a form of coercive control. And that has been effective not only within the Jewish community, but also within state bodies that are charged with recognizing and dealing with domestic violence. So the most prominent and interesting example, and I've just finished an article about this, is in England, where they advocates on behalf of Agunot have been bringing criminal cases under domestic violence laws that were enacted in 2015, arguing that divorce refusal is a form of coercive control. And they were able in the one case that has secured a conviction, were able to point to financial abuse, threats that the wife would never be free, um, and had succeeded in having that form of get refusal recognized as a form of domestic violence. And the husband was actually sentenced to 18 months in prison for that.
Oh, wow.
Wow.
Great.
It's more complicated in the U.S. because of church-state issues. I'm not sure that
Right.
there's anyone who's advocating for that kind of approach here. It has been successfully invoked in California in a family law context as a form of domestic violence that the state should take countenance of in making custody decisions. So there was a case
Hmm.
brought by Esther Machner, who's a lawyer who runs a group called Get Divorce Justice in California, in which she offered expert evidence that the kind of get refusal the husband was engaging in and sort of the threats and micromanaging of the wife should be recognized as domestic violence, and it was taken into account in order to deny shared custody in that situation.
So if a get is refused, what is the impact on or potential impact on the person the woman, the wife who is asking for the get, and what are the consequences to her of not getting that relief?
So, and that's important. That's important for understanding why get-based extortion has some teeth into it. So,
Hmm.
a man who is not divorced from his first wife has a lot more freedom. In theory, both a husband and a wife can refuse uh, to be engaged with a divorce process, but a wife's refusal leaves a husband with some options. A husband's refusal leaves a wife with very few options. So, a man who is refusing to divorce his wife or is unable to divorce his wife can have relationships with other women. It's frowned upon, but he could. And any children who were born of those relationships would not be illegitimate. Illegitimacy under Jewish law is not born outside of wedlock. It's born to a woman who is married to someone other than the father. So
Huh.
there isn't a risk of illegitimacy for children born of his adulterous relationship. If the woman is considered still married to the first husband who refuses to divorce her and becomes involved in a relationship or enters into a secular marriage without being divorced by the first husband, any children who are born from that relationship are considered the products of adultery, and they're described as mamzerim, or illegitimate, and they have a significant status disability. They are not able to marry within the Jewish community, and that is a heritable disability that goes on for 10 generations. So it would render them unable to marry within, certainly within the Orthodox world.
And I assume there'd be some ostracizing of the person in certain communities as well.
Yeah.
I'm wondering if the man in that scenario had refused to give a get to his wife, but engaged in another, he couldn't legitimately marry somebody else. So when he hadn't given a get to his first wife,
Oh,
correct?
you would think that, but no. Um, and it is rare, but it does happen that a husband can argue to a rabbinical court that his wife is uh, refusing to receive a religious divorce unreasonably, either because she has some mental illness so that she's not competent to receive it, or that she simply is refusing in an inappropriate way. And a man has the capacity to get permission of a rabbinical court to take a second wife without divorcing the first wife. He can deposit a religious divorce sort of in escrow with the rabbinical court and say, you can go pick up your divorce anytime you want. And then he can be permitted to marry a second.
So
And it has happened here in the U.S.
and if that happens, and there are children born of that second marriage, they'd be considered legitimate in the eyes of the religious,
Yes.
courts,
Yes.
even though.
It's only the woman's infidelity that creates the problem, not a man's infidelity.
And how does this?
Not surprising.
Yeah, exactly. This seems to have a deep tradition. Now, we've talked a lot about the U.S. and a little bit about England. When we talk, if we fly 6,000 miles away to Israel,
Mhm.
are the impacts similar, different? How does it play out with the courts and the laws of marriage there?
So in Israel, there is no secular marriage or secular divorce. There, as a holdover from the Ottoman millet system, there are different systems of personal law that apply to different religious communities. So there are Islamic courts, there are different Christian courts, there are rabbinical courts, but there are, for purposes of marriage and divorce, there aren't secular laws that permit one to enter into a secular marriage or secure a secular divorce. So any person who is Jewish, whether they got married in Israel or got married elsewhere and moved to Israel, would have to go to the rabbinical courts to get a divorce. Those rabbinical courts are supported by the state, and the rabbis who sit in them are employees of the state. They tend to be very conservative in their points of view and not terribly sympathetic to agunot, to women who appear before them. They do have more remedies at their disposal than are available outside of Israel because there isn't a separation of church and state, or synagogue and state. So there is a capacity to use some strategies to try and coerce a man to give a divorce. Uh, they can remove licenses that he holds, driver's licenses, professional licenses. They can seize bank accounts. They can seize passports. On occasion, they can put a man in jail if he disobeys a rabbinical court order that he ought to deliver a religious divorce. There are certain situations in which the court can't give it the divorce on his behalf, but they can tell him that he ought to do it.
Mm-hmm.
So in that situation, if he is not in compliance with their order, they can ask the instrumentalities of the state to try and encourage him to do so by removing
So,
privileges or imprisoning him.
so this is fascinating. When you talk about sort of the Ottoman Empire and that there are these different factions of courts, different religious factions of courts within Israel, as if it weren't complicated enough already as a place. How much or different are the remedies if you're knowledgeable on this or not, between the various religious entitlements of those courts?
I'm not really in a position to. I'm not an expert on Islamic law or the how would divorce, whether it's even available under.
I mean, I just wonder if there are just a curiosity question, but like how much has been studied about like the overlap between these religions and how much the coercive control and sort of structure of marriage within any of those religious um institutions is similar or different.
Yeah, it's a good question. I haven't read. I'm not familiar with much about what the Christian courts do at all, and whether they do permit divorce. There's some work on Sharia courts, but they're not administering Israeli law. So uh, in in rabbinical courts, there's like they're shaped by Israeli secular law and in relationship to it. So if you if a Jewish couple is getting divorced in Israel, they have to go to the rabbinical court for the divorce. There's no one else who can do that. On ancillary matters, they can either go to secular court or rabbinical court. So there's often a race to the courthouse. It's if you're a woman, you should go to secular court. You will do better there. Um, in terms of family, the range of ancillary issues. If you're a man, you might want to go to rabbinical court because you have more power in rabbinical court. And there certainly have been studies that demonstrate that women do better on the ancillary matters if they go to secular court. So there are two ways of, as in secular, in the secular world, marriage can end in three ways. It can end through the death of one of the parties. It can end through divorce. And it can also end through annulment. That is one of the promising elements within Jewish law that can be used to allow women to escape religious marriages when the husband is refusing to deliver a religious divorce. The marriage can be set aside, just in the way that secular marriages can be set aside for some kind of fundamental defect. For the most part, those defects are very technical ones, like the husband didn't own the ring that he used in the ceremony, so there was no consideration. Or the witnesses who signed the ketubah. So for the Aramaic ketubah, the bride and groom don't sign. It's two male kosher witnesses sign. So go back and find some evidence that, one of the witnesses was sketchy in some way, and that could be a grounds for setting aside the marriage. There are some rabbinical courts who are willing to use more robust reasons for setting aside annulling a marriage. For example, there was a case in Sfat in Israel maybe 10 years ago involving a man who was injured in a car accident and was in a permanent vegetative state. And the court determined that they could set aside the marriage because it was sort of consistent with what his intentions would have been. So sort of, imagining sort of substituting consent.
It's like a Rogers decision in Massachusetts, like substituted judgment in the event of,
yeah. So, and then increasingly there's an idea that marriages should be annulled for domestic violence, that no woman would have chosen to marry someone who had a propensity to this kind of behavior. So this is a fundamental mistake that was hidden at the time of marriage, and had she known, she would not have married him. Much more controversial, but an emerging possibility.
So what's the difference then in terms of the community between a get and an annulment?
So a get requires the husband's compliance and involvement, and an annulment does not.
Right.
It obviates the need for anything on his part. Just,
and both of them have the marriage dissolved that allows the woman then to go on and marry and continue to be part of the community and not have the challenges that the get refusal, if that does occur, would happen.
If a marriage is annulled, are the children of the marriage considered legitimate? If there were children of the marriage? And is the state or is the rabbinical court entitled to look at a division of assets or maintenance or anything? Or is that like when it's annulled and it's over, is it over from the outset? Then are there no entitlements to support or an asset division?
It doesn't have an impact on legitimacy. It's a good question about impact on assets. I don't know. It happens so rarely, and generally the focus in discussions is on the impact on the marriage itself, not on the ancillary issues. So I don't know that.
And I wonder if, just a curiosity question, when I think of the annulment statute in the state law, like the only time I've ever actually used it, although there are a few, in Massachusetts at least, a few different ways you can use it, is in a marriage of less than a year. So sort of that mistake, long date, whoops, didn't mean to do it idea of a marriage. So generally not assets, maintenance, children, involved. But I'm wondering, although sometimes in a Catholic marriage where people wanted to obtain an annulment from the church, from the Vatican, it could be a 30-year marriage. And then people would say, look, I want to be able to, in a similar way to people who feel tied to Judaism in a traditional way, say, I want to be able to take communion. I want to be able to participate in the rituals of the Catholic Church. And without the annulment, I can't.
Mm-hmm.
And that's complicated to receive from the Vatican. And not always, people don't always feel like they have equal access.
Right.
Yeah, and I think that's correct. I don't know a lot about annulment in the Catholic Church, but I do think there is some impact based on who is sitting in the papacy at that time and what their leadership looks like in terms of how strictly they do or do not follow the annulment guidelines and rules. And there
might be better or worse with the new Pope.
Oh, interesting.
I would guess better. Because I think that he appears to be, from everything that I understand and have read, he appears to be compassionate and caring and more modern than not Pope Francis, but the Pope prior to Francis.
Mm-hmm.
So can we just jump back a little bit we mentioned really briefly same-sex marriages. And we're talking about the get in the context of a man and a woman. And I don't know if any of that's addressed in Talmudic or Jewish law at all, but I'd be interested.
So there are branches within Judaism that recognize same-sex marriage, or Orthodoxy does not, but the conservative movement does. And part of the challenge that they had a few years after recognizing same-sex marriage is to say, oh, well, what does divorce look like now that these couples are married and now want to dissolve their relationship?
That was true in secular law, too.
And the challenge is that same-sex marriage is not based on kiddushin, not based on the same model used for heterosexual couples, which is the acquisition of one spouse by the other, because the capacity to be an acquirer or to be acquired are gender-linked capacities. So a woman doesn't have the capacity to acquire another woman, and a man does not have the capacity to be acquired by another man. So they couldn't use kiddushin, which with its attendant problem of how do we get out of this in an egalitarian way, as a model. So they have used alternative models of Jewish marriage, some of which have been drawn up by feminist rabbinical scholars over the last 20 years. So one is Rachel Adler's model of Brit Achuvim, which is a covenant of friends, which uses kind of a partnership model that they both buy into a partnership and then they dissolve the partnership. There are other models as well, but for same-sex couples, it is an egalitarian model, so it can be dissolved by either party. So they don't have the aguna problem. And that has been pointed to as an exemplary model for other couples who are of opposite sex who might want to marry and create a Jewishly valid legal relationship that doesn't have the problem of this one-sided incapacity to exit.
So has the conservative movement evolved in that way to use egalitarian ketubas for men and women and in same-sex marriages, or not really?
So I'm a big fan of the conservative movement. But what they do, generally they don't take a single position. Generally they will offer multiple positions and say clergy within the movement can choose to do what they wish to do. So I actually published a roundtable on this a couple of years ago. There were two opinions about alternatives to Kiddushin that were published by the Rabbinical Council of the Conservative Movement. One by Rabbi Gail Leibovitz, arguing that Kiddushin could not be saved and we should be using partnership-like alternatives. The other by Rabbi Pamela Barmash, arguing that it could be saved and you could reinterpret the Kiddushin model in a more egalitarian way. So both those options are out there, and you know, if you go to more Jewish weddings, keep an eye on what kind of ketubah they're reading out at the moment, and maybe there's an element of partnership to it as opposed to the traditional acquisition language.
And at a Reform or Reconstructionist Jewish ceremony, you're likely to see something that wouldn't be allowed by any of the other.
Well, I mean, this may be changing, but the Reform movement doesn't regard itself as a halachic, as bound by Jewish law in the same way. So in many Reform communities, they consider the Jewish marriage to be terminated when the secular marriage is terminated, and don't require a religious divorce. Although I have seen documents, model documents for Reform religious divorces, but often those are issued because people want them for a sense of closure, not really because it has some legal significance. And that's not to be dispensed with. Like, many people will seek a religious divorce, not because they really care about the Jewish law element to it. Certainly people who identify as Orthodox do, many conservatives do, but I've seen people in the Boston area who have sought religious divorces from the Orthodox rabbinical court just because they didn't feel like they weren't finished when they got divorced in the secular.
Well, in the same,
No one heard their story. They wanted a rabbi to hear their story and say, "I'm sorry this happened to you. Your marriage is over. Go on and find happiness again." And so they wanted that sense of closure.
I've worked with a couple of people who've had their own sort of beachside ceremonies of divorce even with their children, just to sort of like honor what's been and to recognize their commitment to live as a restructured family in a way that they want as they move forward, but to acknowledge that they won't remain married in the way that they have been. And because the secular court judgment didn't feel sufficient for them as humans.
Yeah, I was going to speak to that coming from the bench, right? I mean, I didn't have the ability or the capacity to necessarily hear everybody's story about how they got to me, right? I mean, I heard what I needed to hear, but a lot of times people wanted to talk about infidelity or about other issues that really weren't significant to what I was required to do. So the power of being able to tell that story, whether it's in the rabbinical court or on the beach, is, I think, a powerful uh, solution for many people.
Yeah, I mean, I think it's just, divorce doesn't really have rituals the way funerals exist, or like the way that it is a communal healing for people. And it's a sad moment, no matter how it occurs for most people. And I think, these rituals didn't grow out of nowhere, in terms of trying to create peace and trying to create an ability to move forward.
Hmm.
So as we have this conversation about, this deep dive into religious law that I think I've learned a lot, and hopefully our audience has too, as secular lawyers, what can we be aware of, and what should we do? How do these things interrelate? And can you draw some good conclusions for us from the thoughts we've been discussing?
Sure. Well, as a practice discipline, if you have a Jewish couple or Jewish parties involved. Ask whether there was a ketubah. Ask if getting a religious divorce is something that's important to them. And make sure that that's dealt with early on. Either that the get is delivered before the secular divorce is completed, so that it doesn't become a bargaining chip, or that a commitment to deliver the religious divorce before this secular divorce is completed is written into a separation agreement or a divorce settlement. So that's really important. And we at the Boston Aguna Task Force have some sample language for Massachusetts that we recommend that you might want to incorporate into those agreements that would be both valid under Jewish law and valid under secular law. There are also resources in New York and other jurisdictions that could be helpful. And just reach out to me if you want to be put in touch with people in your state who might be helpful.
Awesome. And if you could share those with us, we would be grateful.
Okay. The other thing to think about, I think, would just to be aware of some of the ways in which uh, get refusers seek to use the secular law to push back against women who are trying to secure a religious divorce. So we have seen recent cases in which the wife or advocates on behalf of the wife have tried to encourage the community to encourage the husband to give her a get. And that might happen through speaking to people in his synagogue, through picketing outside his home, through sending messages and sharing information on social media or on TikTok. And we've seen a number of cases in the last few years in which the husband has tried to turn that around and use it as a way to use secular law remedies to harm the wife. So one are situations in which there have been defamation claims made by the husband or the husband's family, arguing that simply by talking about her sense that she is being denied a religious divorce, she is defaming them. Those have not been successful cases, but they do cost the spouse, the wife.
Isn't truth an absolute defense?
Yes. So they're both nuisance and actual costs in responding to those. I also wanted to draw people's attention to a case called IBB, which was decided in New Jersey last year, and that was one that where the wife had engaged in a social media campaign on TikTok talking about the fact that her husband was withholding a religious divorce and encouraging people who knew her husband to tell him this is not on. Why don't you release your wife? He went to the court and got a restraining order against her, arguing that he was at risk of domestic violence because the Jewish community was so opposed to divorce refusal that he was at risk of being assaulted. But that is not the case. And ultimately, the case was appealed and was reversed on appeal on the basis that this was not an appropriate ground for issuing a domestic violence restraining order, that he was not at risk, that she had the freedom of speech to make these kind of statements about her own life in this peaceful way, and that the First Amendment covered encouraging, boycotting, and expressing disapproval to others for their misconduct. But those are both sort of interesting ways in which secular law can be used to push back on some of the strategies that women who are being refused divorce and their advocates have developed. One thing we didn't talk about was get laws. So not in Massachusetts, but in other jurisdictions, well, in the U.S., really only in New York State, there are laws on the books that allow someone who is being refused a religious remarriage by their spouse to make that relevant to the secular divorce. So in New York State, there are provisions that both allow the secular divorce to be withheld until the religious divorce is delivered in some cases, and also allow divorce-based extortion and get refusal to be a factor taken into account when determining maintenance. So those are things that you might look at if you're practicing in those states. There are also those kind of get laws in other jurisdictions. There's one in Canada, there's one in South Africa, there's one in England. So you could look to those for sort of comparative relevance.
That's great. I also think it's fascinating that, I mean, only within this past year did coercive control become a statutory consideration in Massachusetts in terms of restraining orders. So, this has been going on for many thousands of years, and yet we're seeing sort of this interplay between the secular law and the religious law, even in current times. So this has been so enlightening, and I really, really have enjoyed this conversation so much. Before we let you go, I've got to ask you, how did your interest in this topic become your sort of passion in your work?
So I guess I had been familiar with the Canadian get law, which provides that if a spouse is not complying with or facilitating the religious remarriage of the other spouse, they're not entitled to file any documents, which I thought was very interesting. I just learned about that when I was doing the bar admissions course in Canada. And then later I was in graduate school, and I was working on the sort of political philosophy issues around respecting rights to culture and respecting rights to gender equality. I was doing that in the context of post-apartheid South Africa and lived there for a while. And then I went to a conference that was actually held at Brandeis when I was a visitor at Brandeis on sabbatical by the Jewish Orthodox Feminist Alliance, which was a fairly new group at the time. And one of the issues they were talking about was the ins and outs of the Jewish divorce issue. And I thought, wow, this really has significant overlap with the kind of issues I've been exploring in my other work. But these are issues that are in my own tradition. And I came home and sort of told my husband at the conference, and he was like, wow, you seem really excited about this. Why don't you write about this? And I'm like, okay, well, maybe I will. That ended up being sort of a new area of research for me.
Oh, that's great. That's great.
I love that. That's just like a full circle story for you. So that's sort of wonderful.
Yeah. So, Lisa, thank you so much for taking the time to talk with us today. I know I've learned a lot from our 45-minute or so conversation, and would love to have you back as your research continues.
All right. Thank you. It's a real pleasure.